7474 FD, the state of Michigan versus James Douglas Winsel.
Good morning, Your Honor. James Gazicki on behalf of Mr. Winsel. Waive reading of the complaint, stand mute, request court-appointed attorney, also ex parte order to preserve.
All right, Mr. Winsel, can you tell me your first and last name?
James Winsel.
All right, Mr. Winsel, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have a right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearings. In the event you can't afford an attorney, one will be appointed to represent you, as Mr. Gazicki was appointed to represent you today. And I have signed an order so that you have an attorney at your next hearing. I've also signed the ex parte order preserving evidence to ensure your counsel can get discovery on your case. As to bond, Mr. Gazicki.
And there it is, motion denied, case moving forward. The judge isn't budging despite all the challenges. Quick takeaway. You can argue probable cause, you can argue bond conditions, but at the end of the day, the burden of proof shifts to trial. Now, what do you think? Did the defendant make strong legal points or just stall the process?
Oh, wait a second. You have 2 days within the next 21 days, Mr. Winsel. Your first date is your probable cause conference, and that is set for June 30th, 2025. You can appear at that hearing via Zoom. Following that will be your preliminary examination, and that will occur on July 7th, 2025 in person at the 23rd District Court, and you'll receive notice of both of those dates in the mail. As to bond, Mr. Gazicki.
Your Honor, I'd ask for a personal bond. Mr. Winsel appeared today. Does not appear to be a flight risk.
All right, Mr. Winsel, you did appear today. I'm giving you a personal bond, so you don't have to post any money, okay?
Thank you.
These are the conditions of your bond, sir. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You cannot consume alcohol or illegal drugs. You will be subject to random drug and alcohol testing while this case is pending. You cannot operate a motor vehicle without a valid license. Do you understand all of that, sir?
Yes, I do, but I am on some prescribed medication from surgery.
Okay, well, is it alcohol?
No.
If you're on if you're taking prescribed medications, you'll just need to provide proof of those prescriptions to the probation department, and they're going to contact you to set up your testing, okay? Because you will be tested while you're on bond.
That's fine.
Okay, they'll reach out to you, sir. Make sure you answer if you get a weird number, so you know that you so that you okay, so that you are in compliance. All right, you're all set. All right, on 2-5, thank you, sir. Have a good day. On 251.
Those will be mailed to me?
Yes, sir. Mr. Winsel, they're going to call you as well.
Okay.
So you'll receive notice of your next 2 court dates on the 30th, but you know you need to be here next Monday morning, and you need to be here the morning of the 7th. Those are your next 2 hearings, but you'll receive notice from the probation department about testing. Understood?
Understood. Thank you, Your Honor.
All right, you're all set, sir. Okay, now we're on Eric Martin. This is 251756, the people.
Good morning, Your Honor. James Gazicki on behalf of Mr. Martin. Your Honor, he's waiving his right to a trial by jury, requesting trial by this court. And also, can I address bond, Your Honor?
Yeah, I signed the order granting discovery. Mr. Martin, you understand that you have a constitutional right to a trial by jury?
I comprehend that.
Do you understand that, sir?
I comprehend it. I just want to add, as I told him, I really don't consent to no jurisdiction of this court, but since I'm being forced to make the choice, I'm saying an Article 3 judge is going to be the choice, the forced choice. Article 3 judge.
Okay.
Even though the case shouldn't go, let me mention this too now. The case shouldn't even go that far. We shouldn't even be wasting taxpayers' money, nor my time in here. First of all, I proved my sister lying before on me with the same type of charge, Nessick, okay? I don't know the case number right now. I asked Jasinski to find out what it is. But in the same court, 23rd District Court, the judge is seeing she lied when I questioned her, did you swing at me before I kicked you? She answered no to that, and it was seen on the camera she lied. This is especially why I should not be made to wait on this.
Mr. Martin, you have a constitutional right to a trial by jury. Are you voluntarily waiving the right to a trial by jury?
Since I'm being forced to make
Well, you're not being forced to make any choices.
Well,
You can
I
have a
make one or
trial by.
two, so I am being forced.
Mr. Martin, listen, we can get through this, or we can go back and forth, and then I end up muting you, and then that's how we go forward.
Notice how the defendant keeps pushing this Article 3 judge argument. It's a classic sovereign citizen tactic. Judges hear this all the time, and it never works. What would you do if you were on the bench? Stay patient like this judge, or shut it down faster.
So let's see if we can do this without that, okay? You have a constitutional right to a trial by jury on this case. Are you waiving your right to a jury trial?
Yes.
And you understand that I'm the judge of the court, that I will be the trier of fact on your case?
Well, I want a motion for a judge trial, but I'm going to object to you being the judge based on past constitutional violations.
Okay, well, your motion for recusal is denied. So now, Mr. Martin, are you electing for me to try the case, yes or no?
In that forced the sense, yes.
Well, you have two choices, a jury trial or me. Out of those two choices, which one do you like?
Are you an Article 3 judge?
Mr. Martin, I'm not going to entertain jurisdictional arguments. I'm asking you, do you want a trial by a judge or a jury? And I'm being very patient.
By a judge, I already said Article 3 judge. Article 3 judge.
Okay, well, I will be your judge. I've made that clear. This is a case I have jurisdiction over. It's a misdemeanor that's alleged to have occurred in the city of Taylor. So you're indicating to me that you're relinquishing your rights to a trial by a jury, and you'll be tried by me. And you understand, you've had a chance to talk to your lawyer about this, Mr. Martin?
Yep.
Okay.
I also want to make it clear, I have some other things to say. I enforce my right to a Republican form of government under Article 4, Section 4 of the U.S. Constitution, which is why the court don't have jurisdiction over me. And I am the third party beneficiary here. I am not the defendant.
Amy, can you find
despite the fraudulent presumption otherwise.
Possible. All right, give us a second, Mr. Martin. I'm trying to get your jury trial date. We can even do on a state date.
I want to make clear, I'll point out, it's supposed to be 28 days and Saturdays and Sundays are not supposed to be excluded because the 28 days is specific for speedy trials and misdemeanors. And since that's specific under the court rules, it should be 28 days without excluding Saturdays and Sundays or legal holidays. That's made clear, I want to say, under the rule that dictates speedy trial, MCR 6.004C, and also MCR 1.103, the applicability rules that clearly says, where a rule is specific, it applies to that. So that the specific rules control over general rules.
Okay, Madam Prosecutor, how many witnesses?
I would say maximum 3.
Okay, Mr. Gazicki, how many witnesses?
Your Honor, first of all, I just want to put on the record that Mr. Martin in the past has not wanted my representation of him. Today, he says it's okay for me to represent him. I just wanted that on the record. I also advise Mr. Martin that his arguments that he makes about sovereign citizens and that is something that I can't follow, nor can I ask the court to follow it. Just so that's on the record. As far as witnesses goes right now, Your Honor, we would say 1.
Okay.
Can we approach?
I mean, Mr. Gazicki's in the other room. Mr. Gazicki, can you come on in? We'll meet you in the back hallway. All right, Mr. Martin, 1 second.
Yeah, and I got something to say too, while we get time in response to what he said. And for the record, the judge has abandoned court. This case is dismissed. I order this case be dismissed. Case number 25-1756-SM.
Okay, Mr. Martin requested that I ask this court if he can have a no condition type bond in this matter.
Okay, here's the problem. I'm just gonna say it on the record. Request for a bond modification is denied. Mr. Martin had a very simple bond condition that he not go back to the residence. I know he doesn't think I can tell him that, but he's wrong. And he went back to the residence and got arrested again, allegedly, for being at the home when there was a no contact provision in place. So he clearly has a history of non-compliance. He doesn't think the court has jurisdiction over him. And the only way I can assure his presence and assure the safety of the community is to keep Mr. Martin in custody, because he will not comply with my bond conditions. There's no such thing as an unconditional bond. So, okay, bond denied. And Mr. Martin, if you want to file motions that Mr. Gazicki legally could not file in good faith, feel free to file them. He's governed by court rules. He cannot file frivolous motions. So if you want to file more motions, feel free, get it, go at it. But Mr. Gazicki has indicated for the record, he will only be filing appropriate motions with this court. We'll see everyone back on the jury trial. That's my first date.
I have motions to make right now. I have some motions before we leave. I have some motions. Okay, and that is okay. Well, first, objection to what you just said, your statement about, there's no such thing as an unconditional bond. Yes, it's my right to be presumed innocent under the due process. The due process right, be presumed innocent before guilty. Because I am presumed innocent, that is why any bond conditions violate that right. So
okay, motion denied. What's your next one?
Okay, and I motion to dismiss because there is no probable cause. It is her word against mine. She's lying. She's been caught lying before. And there is no evidence at all. We have no case. There's no evidence. And that is not probable cause, as the U.S. Supreme Court said in Beck versus Ohio.
Well, it's a misdemeanor, so we're not having a preliminary exam. We're having a bench trial. And the prosecutor will have to prove the allegations beyond a reasonable doubt. And at that time, Mr. Martin, if at trial date, I assure you this, if you picked a bench trial. I was a practicing attorney for years. I promise you this. If she cannot prove her case beyond a reasonable doubt, the case will be dismissed.
Okay, but anyways, let me finish talking. I didn't finish talking about the motion to dismiss.
I know, but Mr. Martin,
as of right now,
what's your last motion? Do you have one more?
Let me finish.
This is where it gets spiciest, basically saying, her word against mine isn't enough. But here's the catch. In many cases, especially domestic disputes, one person's testimony alone can establish probable cause. Do you think that's fair, or should courts require more solid evidence before moving forward?
If I want to finish the motion just based on no probable cause,
okay.
As the U.S. Supreme Court said in Beck versus Ohio, or it was Ohio versus Beck, I forget which word is first, but the probable cause is defined as fact sufficient for the belief. Her word against mine. I told the cop she lied on me. Okay, her word against me. Somebody have her word against mine. That's all there is. So that's not fact sufficient for the belief. There's no probable cause now. The case should be. Come on, let me finish.
Okay, denied.
The case should be dismissed now.
We'll see you back on your trial date. Have a good day. Okay.